Real talk, real people, real radio. HighFrequencyRadioNetwork.com.
The motive of our founding fathers was totally self-centered. It was their personal greed that inspired them to accept the task of writing the Constitution of the United States and not patriotism. In actuality, the United States is not a land or a place. It is a corporation, a legal fiction that existed well before the Revolutionary War. See Republica versus Sween. The Constitution of the United States was written in secret by the founding fathers and was never presented to the colonists for a vote. Surely, any document as important as this demanded the approval of the people it governed. Well, it wasn't presented for a vote because the Constitution wasn't created for we the people. It was created by and for the founding fathers, their family, heirs, and their posterity. The Constitution is a business plan, and any reference contained within it that appears to be the safeguard of a right is there because none of the founding fathers trusted each other. The safeguards were intended to prevent any one or group of them from cutting out the others, proving that there is no honor among thieves. Americans are not unlike all other humans who inhabit the earth. All human beings possess malleable minds, which are minds that can be shaped and controlled. And when government shapes and controls a mind, it's called brainwashing. Brainwashing causes the subject to become functionally illiterate. In America, our functional ignorance excels in the areas of history, government, and law, which really are one and the same. 98% of the officials in public office are lawyers, and these so-called representatives set policy and created the laws that govern this society. Their use of Greek and Latin terms in law and the habit of changing definitions and usage of common words is intentional. The intent is to confound and confuse the general public and to hide the treason they are implementing. And so that members of the public are forced or decide to hire a lawyer out of frustration rather than try to represent themselves in our fictional courts of law. As you read on, I'll explain to you why and how our courts of law are fictional. And I want to stop right there and really go in on that part right there. When you read the definition of a legal fiction in the 8th edition Black's Law Dictionary and the expert commentary, it's going to tell you that it is that they are doing that to get by the blur-eyed watchers of our legal treasures. Legal fiction, an assumption that something is true even though it may be untrue, made especially in judicial reasoning to alter how a legal rule operates. Specifically, a device by which a legal rule or institution is diverted from its original purpose to accomplish indirectly some other objective. The construct of trust is an example of a legal fiction, also termed fiction of law, fictio juris. I employ the expression legal fiction to signify any assumption which conceals or affects to conceal the fact that a rule of law has undergone alteration, its letter remaining unchanged, its operation being modified. It is not difficult to understand why fictions in all of their forms are particularly congenial to the infancy of society. They satisfy the desire for improvement, which is not quite wanting. At the same time, they do not offend the superstitious disrelish for change, which is always present. Henry S. Maine, Ancient Law, pages 21 through 22, 17th edition, 1901. Legal fiction is the mask that progress must wear to pass the faithful but blare-eyed watchers of our ancient legal treasures. But though legal fictions are useful in thus mitigating or absorbing the shock of innovation, they work havoc in the form of intellectual confusion. Morris R. Cohen, Law and the Social Order, page 126, 1933. Go and read it in a 8th edition Black's Law Dictionary. They basically tell you this. They just put it in words you can't understand. There never has been a law on the books created by the Congress which made it illegal for a common man to practice law. Every judge of a district, circuit, or appeal court, except justices and magistrates, is a lawyer and a member of the bar. These judges have the authority to establish local rules of court, and those mentioned have created a local rule that prevents common people from representing any other person in their court or to practice law without a license. A license requires that you produce your Bar Association number. For those who don't know, the Bar Association is simply a lawyers' union, and when lawyers are accepted into the bar, they're required to swear allegiance to a foreign power. The American Bar Association is a branch of a national organization titled the National Lawyers Guild Communist Party and can be found recorded in the United States Code 28 U.S.C. 3002, Section 15A. They have become so big and entrenched they no longer fear reprisal. Whenever I tell people there is no actual law that makes it a crime to represent another person in court, the reaction is, "That's a lie! That's a goddamn lie!" I remind them that Abraham Lincoln and Clarence Darrow never went to law school or passed the bar. But the reaction is understandable because the bar is a very powerful organization and its members have infiltrated every niche of American life and business. How many times in your life have you heard you can't practice law without a license? I've heard it said in numerous movies spanning 100 years, and my mother's soaps, and by comedians and jokes and theatrical skits. I've seen the phrase in printed newspaper articles, magazines, and heard it on the radio. Before I learned the truth about this fact, even my personal lawyer made that comment to me. We all have been brainwashed to believe a lie, and because we've heard it so often from people we trust and who are supposed to have our best interests at heart, we all just assume it must be true. How many other lies have you assumed it must be true? And I've said this in court. I was in California in a court with someone, and he was giving his presenting his argument before the judge, trying to get the judge to honor her oath of office. And I was sitting behind him behind the bar. I wasn't sitting at the table with him, but he was standing up, and I stood up and leaned across the bar to whisper something into his ear. And that made the judge go off on me. She said, sir, do you have a license to practice law? Everybody, and then even the damn clerk jumped up. Start running over to, sir, where's your license to practice law? All this right here. I sat down calmly. Bailiff started walking over to me. I sat back calmly. And this is what I said. You say this to these judges. I'm sorry, I wasn't aware that the practice of law could be licensed. Our American society has been lied to by their government and lawyers more times than you will sign your name in your lifetime. We've been indoctrinated, brainwashed to believe that the Constitution was created for we the people. The purpose behind these lies is to make you believe that you are free, safe, protected, and secure. And it's all an hallucination. How many of you have studied each line of the Constitution, the statutes at large, and the Articles of Confederation, armed with a reputable dictionary or a law dictionary from that era? If you take the time to do this, you will soon discover that the true purpose of the Constitution was to create a business plan and to establish a military government for the protection of the Founding Fathers, the King's commerce, protection of his agents, and the future control of his subject slaves. Even the preamble of the U.S. Constitution is a clue to the lie which states, to ourselves and our posterity. If you never saw the title, the Constitution, and you were never told what this document was about, what do you think would be your first impression upon hearing a reading, to ourselves and our posterity? The Constitution is not for we the people, and America is a matrix of misinformation. In the eyes of those in control, America is nothing more than a large plantation, and we the people are slaves. In many U.S. and world treaties, the term high contracting powers is used to define your masters. Everyone else is considered by them to be their slaves. All of the founding fathers had two things in common. They all shared the gift of a good education or were gifted individuals, and they all came from families of business and of substance. These men all suffered from visions of grandeur. They viewed America as their one opportunity to make them powerful and wealthy, to ourselves and our posterity. Initially, their plan was to steal America away from the king, despite the fact that King George funded the exploration of the New World, which legally gave him first claim to all new continents discovered. The seizure of the Americas by the king's explorers was not as if it had been depicted in our history books, presented to us by our government in our government-controlled public schools. Native Americans, the Indians, were murdered, their villages burned, many were enslaved, infected by diseases brought from England, and their lands taken by force and the threat of force by these early explorers. The Indians were labeled savages by the immigrant explorers from England, but the true savages were our English ancestors. One thing the Founding Fathers did not know was that all of the king's lands and all future acquisitions, such as the Americas, have been given and pledged by King John to Pope Innocent III and the Holy Roman Church by the Treaty of 1213. After that fact was proven to the Founding Fathers, King George and the representatives from the Vatican decided to use the constitutional draft created by the Founding Fathers to further their plan to control the colonists. Control attained by bringing the colonists to their knees in debt. Any way you read it, the Constitution was never written with the intent of benefiting the American people. Did you know that 98% of law schools in America and England do not include constitutional law as a part of their law curriculum? The reason for this phenomenon is because constitutional law does not apply to or affect the enforcement of statutes, codes, or administrative regulations which have replaced constitutional law, the common law, public law, and penal law, and which have been designed to control you. In other words, constitutional law is taught as an elective at Harvard, Yale, and Cambridge, and only for students of law who are planning a future career in government. This should make sense to you as you read on. In the true history of America, neither side won the Revolutionary War. At first, the appearance of English troops in the colonies was simply a show of force by King George, intended to intimidate the colonists and force them to pay him taxes. Factually, back in England, English soldiers refused to take up arms against the colonists because they were English citizens and relatives. Mr. Mayer Amschel Bauer, founder of the Rothschild banking empire, by this time owned the king. Mr. Bauer had extended unlimited credit to the king and arranged contracts with him, which permitted the Rothschild tax collectors to represent and collect the king's tax from the king's subjects. This is the origin of the concept behind the establishment of the IRS. It was Bauer who suggested to King George that he enforce a tax against the colonists in the New World, since the tax being collected in England was barely enough to pay the interest on the king's loans. When English soldiers refused to fight, Mr. Bauer negotiated a contract with unemployed Russian/Germanic soldiers to fight for King George at a cost of 50 cents a day. Bauer then informed King George that he had hired these soldiers in the king's name, but at a cost of $1 a day. King George utilized these soldiers, dressed them in English soldier uniforms, and ordered his career officers to command them. When his show of force in the colony failed, Mr. Bauer suggested that King George finance the colonists in their war efforts against him and bring the colonists to their knees in debt. The king succeeded in accomplishing this through his appointed civilian figureheads in charge of his government of France. Mr. Bauer wanted to expand his banking empire into the colonies. He discovered that the colonists didn't trade in gold or silver, but used scrip as the basis of their economy. The scrip money used were promissory notes printed by the colonists. All the colonists agreed that they would consider these notes the lawful currency of the colonies, but Mr. Bauer wanted gold or silver and induced the king to demand that his tax in the colonies be paid in gold or silver. It was that condition that broke the camel's back and caused the Boston Tea Party. Whoever controls the money controls the country. Surreptitiously, King George infiltrated the colonies in their futile attempt to form a new government using spies composed of English lawyers and English aristocrats loyal to him. Spies' assignment was to infiltrate the new government, carry out the plan to defeat the colonists through debt, and establish regular reports to the king. The church also had their appointed representatives in place to protect and ensure that their interest is being observed. Much of the loans received from the French went into the pockets of the Founding Fathers. The Founding Fathers eventually conceded to King George and the Holy Roman Church's demands, by and through the intervention and persuasiveness of the king's spies. Ironically, the common denominator or glue that eventually bound King George, the Founding Fathers, the English lawyers, and English aristocrats together was a secret society called the Illuminati. Even Paul Revere and Benjamin Franklin were members of the Illuminati. This secret society had a criminal and deadly past in Europe and in America. They were eventually renamed the Free and Accepted Masons. The majority of the regular membership of the Free and Accepted Masons do not know about the Illuminati influence within their rank and file. The Illuminati members operate out of a special sect society separate from the regular Masonic membership and are found in every branch of the Free and Accepted Masons of the world. Think about the colonists who we have been taught to revere by our public school system. All of these individuals were members of this secret society, and all were traitors. Our history books also instruct us to apostathize the Founding Fathers. Don't hold them in reverence, hold them in contempt. By and through their intervention, slaves you are and slaves you will ever be. An example of a man in history we've been taught to revere is Benjamin Franklin. Would it shock you to learn that he was on the king's payroll, and his many trips to England was actually to report on the colonial government to King George? The Declaration of Independence is another story omitted from our history books. Of the 51 men involved in the creation of the Declaration of Independence, 21 were actually traitors and on the king's payroll. During the Revolutionary War, English officers were provided the names, addresses, and family members of these 30 loyalists involved in the creation and signing of the Declaration of Independence. The English soldiers have been ordered to hunt down and murder all 30 loyalists, their wives, children, and all relatives, with further instructions to burn their bodies inside their homes. Soldiers are to leave no trace of these men and their families, to wipe out their existence for an eternity. The history of civilization has taught us all that martyrs are dangerous to men of power, and King George didn't want to leave any martyrs. It is pretty obvious who provided the detailed information about the 30 loyalists, their family, and addresses. At first glance, it appeared that Guy Madison of Virginia was so concerned about lawyers holding any position in American government that he championed the 13th Amendment, which barred lawyers from holding any public office in government. The 13th Amendment was ratified but never made it into print in our government-controlled school books and public classrooms. The amendment was surreptitiously removed and replaced by the 14th Amendment. The 15th Amendment became the 14th, and so on. Madison's efforts appear admirable, but his later actions as a member of the First Congress suggest his only real concern was to block lawyers from undermining the theft that he and his compatriots had planned for America. Once the cost of the Revolutionary War sufficiently placed the colonists in debt, the English soldiers were ordered to dispense with their efforts, recover their arms, and within the next 8 years, they eventually returned to England. The colonists were so glad to see the fighting stop that they allowed the soldiers to retreat and exit America peacefully. There's an old maxim that states, "The first to leave the field of battle loses." Pursuant to this maxim, the Founding Fathers proclaimed the colonists the victors. A maxim is a great truth that is time-honored and incorruptible. In reality, the war was just a diversion. The colonists had no chance of succeeding in their efforts. Examine the facts for yourself. During this era, England had the largest army and navy in the world. King George owned England, Ireland, and France, having a combined population of about 60 million subjects. The colonists were poorly educated, poorly armed, and composed of farmers, tradesmen, bonded slaves, women and children, and boasted a total population of only 3 million subjects. And considering the undermining that was occurring to their nation by the king's spies and the Founding Fathers, the colonists didn't have a prayer of defeating the English. Americans have been indoctrinated by our federal and state governments and through government-controlled public schools and literature, government-controlled media, and government-controlled churches. Yes, even the churches. To believe that America defeated the English. We celebrate that victory and our so-called independence each year on the 4th of July, and it's all a bunch of propaganda. A carrot to lead the horse and keep this society stupid and passive. We boast today that our country represents the finest schools in the world, but in reality, we're no smarter than the first colonists. We only know more about other things because of new technology, developments during the last 250 years, and yet the average IQ of America is 70.
Let's move on to the next question. Go ahead.
Hi, my name is Jenny. I'm a sophomore, and this is for all three of you. Can you say in one sentence or less what... you know what I mean. Can you say why America is the greatest country in the world?
Diversity and opportunity.
Lewis?
Freedom and freedom. So let's keep it that way.
Will?
The New York Jets.
No, I'm going to hold you to an answer on that. What makes America the greatest country in the world?
Well, Lewis and Sharon said it. Diversity and opportunity and freedom and freedom.
I'm not letting you go back to the airport without answering the question.
Well, our Constitution is a masterpiece. James Madison was a genius. The Declaration of Independence is, for me, the single greatest piece of American writing. You don't look satisfied.
One's a set of laws and the other's a declaration of war. I want a human moment from you. What about the people? Why is America
Not the greatest country in the world, Professor. That's my answer.
You're saying...
Yes.
Let's talk about...
Fine. Sharon, the NEA is a loser. Yeah, it accounts for a penny out of her paycheck, but he gets to hit you with it anytime he wants. It doesn't cost money. It costs votes. It costs airtime and column inches. You know why people don't like liberals? Because they lose.
If liberals are so fucking smart, how come they lose so goddamn always?
Hey, and with a straight face, you're going to tell students that America is so star-spangled awesome that we're the only ones in the world who have freedom?
Canada has freedom. Japan has freedom. The UK, France, Italy, Germany, Spain,
Australia, Belgium has freedom. So 207 sovereign states in the world, like 180 of them have freedom.
All right.
And yeah, you, sorority girl,
just in case you accidentally wander into a voting booth one day,
there's some things you should know. And one of them is, there is absolutely no evidence to support the statement that we're the greatest country in the world. We're 7th in literacy, 27th in math, 22nd in science, 49th in life expectancy, 178th in infant mortality, 3rd in median household income, number 4 in labor force, and number 4 in exports. We lead the world in only 3 categories: number of incarcerated citizens per capita, number of adults who believe angels are real, and defense spending, where we spend more than the next 26 countries combined, 25 of whom are allies. Now, none of this is the fault of a 20-year-old college student, but you nonetheless are, without a doubt, a member of the worst generation ever. So when you ask what makes us the greatest country in the world, I don't know what the fuck you're talking about. Yosemite?
Documented proof that the Constitution was not for us can be found at Powderford, Fay and Company versus Mayor and Alderman of the City of Savannah. This was a court case wherein the plaintiffs sued the City of Savannah for violating what they believe were the constitutionally protected rights. The decision of the judge says it all. But indeed, no private person has the right to complain by suit in court on the ground of a breach of the Constitution. The Constitution, it is true, is a compact, but he, the private person, is not a party to it. The United States Constitution was converted into a trust, and the legal definition of a trust is a legal obligation with respect to property given by one person, donor, to another, trustee, to the advantage of a beneficiary, Americans. The property in this trust includes all land, your personal possessions that you believe you own, and your physical body. The donor of the trust is the King of England and the Holy Roman Church. The trustees are all federal and state public officials, which means that they truly are agents of a foreign power, the King and the Vatican. The reason the Constitution was converted into a trust is because, as a non-trust business plan, the Constitution completely bound the hands of our government officials. By their converting it into a trust, our public officials were then free to make any changes they desired to this government without their constituents' knowledge. The rules of a trust are secret, and no trustee can be compelled to divulge those rules, and the rules can be changed by the trustees without notice to the beneficiary. The one pitfall confronting them and their plan was the fact that by converting the Constitution into a trust, our public officials had to legally assign a beneficiary, and the beneficiary chosen could not offend or be in contrast to the numerous international treaties that were in force. Our public officials wanted to stay in control of the trust as the trustees. However, a trustee cannot also be a beneficiary. So even though the Constitution was never designed or written for the sovereign American people, they unknowingly became the beneficiary of the secret trust, and hence the creation of the propaganda regarding our constitutional rights. All high-ranking public officials, lawyers and judges laugh at the ignorance of people who claim that their constitutional rights have been violated. Lawyers are actually taught to treat the members of the general public as inferior individuals. This also explains the air of arrogance that most lawyers convey in their demeanor and speech.
Real talk, real people, real radio. HighFrequencyRadioNetwork.com.